Hello my dear students, let's now come to your unit 3, that is agency. Now, one thing you keep in mind, normally institute asks one question from each unit. Yes, normally they do that. Sometimes they just ask you two questions from the same unit, but otherwise one question each. So each unit is important. Please do not leave anything in option. Okay. Now, agency, see, up till now we have seen indemnity contract defined, guarantee contract defined, then bailment contract defined, pledge contract defined, but bacha, agency is not defined. The word agent is defined. Now, who is an agent? I will not tell you, we will derive this. So, let's talk about your agent. Let's say P is the principal, Princi, A is the agent, and principal told agent that you sell my goods in the market for 1 lakh. Now agent found X who is ready to buy these goods for 1 lakh. But A will enter into a contract with X. But is A doing it for his own self? No. A is doing it on behalf of P, right? And A is doing it on behalf of P, that's right. And A is representing P in this deal. That means he is an agent. So agent is a person who enters into a contract on behalf of someone else or represents someone else in the course of dealing. He is known as an agent, and the person for whom he is doing all this, he is known as the principal. Right? Now, please tell me, even though agent has entered into a contract with X, still who will be responsible to X? Principal. So even if agent is entering into a contract on your behalf, everywhere the principal is liable. So I'll make one statement. Even if principal is entering into a contract through an agent, can I say it is as good as he himself is entering into a contract? Yes. So there's a Latin term, quid facit per alium facit per se. That means he who acts through an agent, it is actually he himself is acting. In short, principal is gonna be liable. So agent, person employed to do something for another or to represent another in dealings, and the person for whom it is done is the principal. Quid facit per alium facit per se. Now, what are the essentials? First, there has to be an agreement. It can be express, implied, but there has to be an agreement of agency. Secondly, which are consideration? Please tell me. Consideration in agency is obviously, it is optional because it was an exception to no consideration, no contract. Then principal himself should be competent. So capacity to employ an agent, so principal should be competent. And agent also should be competent. But ma'am, we studied that minor can be an agent, right? You studied minor can be an agent, but he is not liable, right? And here they are saying agent should be competent. Let me mix both and I will interpret this as that agent should be a competent person if you want to make him liable. But if you don't want to make him liable only, then it's okay. Then it's okay. So that is your fourth essential. Coming to modes of agency, there are mainly 3 modes of agency. So modes of agency, first one you are having is express, then you are having implied, and then you are having is ratification. Express means expressly you mention that he is your agent or you are transferring your rights. But if I am transferring my power of attorney to Mr. X, Mr. X is going to represent me in deals. Mr. X is going to enter into contract on my behalf. So basically expressly, because power of attorney cannot be done orally, I am expressly giving this that he is my agent. It's express. Or sometimes, you need not mention, it is understood. For example, if I take, I am born and brought up in Mumbai, I am staying in Mumbai, but let's say I have a shop in New Delhi. Now in New Delhi, yes, I have appointed Mr. Singh as the manager of the shop. So in that case, Mr. Singh is going to enter into contracts on my behalf, take care of my shop, sell goods, buy goods. Whatever I was supposed to do, he is doing on my behalf. But I am not saying he is my agent. I am not saying it. It is implied that he is my agent. Even though if you technically see, I am giving him salary, but still he is my implied agent. That means all the rules of agency will become applicable. Then ratification means approval. You have heard this word before also, right? Now what is this ratification I am talking about? Because we just concluded some time back that whatever agent does, principal is going to be liable for that, right? But that way then agent can do anything, any nonsense. So every agent has been given some kind of authority. Only and only if he acts within authority, then only principal is liable. If he acts beyond authority, then agent is going to be personally liable. It's like a partnership. Every partner has been given authority. If he acts within authority, firm is liable. Beyond authority, he is personally liable, right? And bacha, the rules should be same, because don't forget, partnership is also mutual agency only. Yes, every partner is a principal as well as agent. So you will find a lot of rules which are similar to it. So if he acts within authority, princi, beyond authority, agent. But bacha, if he acts beyond authority and it is ratified by the principal, then principal will be liable. Example. Principal told agent that you just sell goods for me. Agent sold the goods and customer gave him 10 lakhs. Ideally, agent should return this 10 lakh to the principal. But what agent did is, agent used this 10 lakhs and he gave this 10 lakhs as loan to Mr. X. And X promises to repay it along with 10% interest. Now, agent is acting beyond authority. But whatever interest X gave to A gave it to P and P quietly accepted it. His actions indicate that he has accepted this transaction, means he has approved this transaction. That means, bacha, the principal is gonna be liable for this. So very simply I can say, if agent is acting beyond authority, that is outside his powers, then principal is having two choices. Principal can either ratify, that is approve, or disown, that is not approve. Bacha, if the principal ratifies, the princi is liable. If he disowns, then agent is gonna be personally liable. That is your ratification. Now they have given you certain rules. Ratification can be express, implied. Ratification should be communicated. It should be within reasonable time. Only valid acts can be ratified. Then ratification should not be obtained by fraud. That is, knowledge of the principal should not be defective. Or ratification should not cause any inconvenience or harm to any third person. So all these, see, ratification here they have given, and these are the essentials. So all these essentials they have given you with the example in your textbook. I just told you all of that. It's very, very simple. Next thing, even if I don't tell you, you know this, bacha. Tell me in normal circumstances who is liable if agent does something? Obviously principal. So normal circumstances and normal course of business, the princi only is going to be liable. What about emergency? This is important from exam point of view. Emergency, again principal is liable, but bacha, 5 conditions are to be satisfied. Now which 5 conditions and what are you supposed to do? If I take example, Manasi is the principal and let's say Mr. Ajit is my agent. And I told Ajit to just transport. I am giving him tomatoes and I am telling him just to transport these tomatoes from one place to another. Okay, now what happens is his work is just to transport. What happens is he is transporting, but in between there was some landslide. Therefore, he was stranded in one village, one small village. So he had to stay there for around 3-4 days to, then only it was all cleaned and then only he could leave. But he is like that, if I am stranded here and if I don't do anything, these tomatoes will rot. It will cause losses to my boss. So what he did is, he tried calling me. But because of this landslide, he could not communicate with me. Therefore, he used his own brain and he sold these tomatoes in the nearby village at whatever price he was getting, because tomatoes were almost on the verge of getting rot. Therefore, Ajit sold these tomatoes at half of the price. This is, by the way, your exam question. So, in this case, Manasi comes to know, can Manasi sue Ajit? Answer is no. Because Ajit is acting in emergency and good faith. See, which are 5 conditions. First, agent should not be in a position to communicate with the principal. He tried to call me, but we could not talk. Second one, there should be an actual emergency. Third one, he should act in good faith. He did not have any bad intention. Fourth one, he should have adopted most practicable course of action. Means normally whatever he would have done with his own goods, he has done that. And lastly, bacha, he has the possession of the goods. If all 5 conditions are satisfied, the principal will be liable for the acts. He can't say that he is acting beyond authority. So that is your 5 points, C, A, B, C, and you will find other 2 as well. Example is also given. But what if I tell you, bacha, he was able to call me, okay? And I told him clearly, Ajit, don't do anything, keep the tomatoes like that. Still, if he sells those tomatoes, that means now he is acting over smart, then he himself is responsible. I am not. Now, these 2 are fine. Coming to your duties and rights. Duties and rights are also very simple, bacha. It is agent's duty to do the principal's business, follow his instructions. Then, in that case, if he does not follow my instructions and if there is any loss, he will have to pay me that loss. Then, I am relying on agent's skill and judgment. Basically, if I am giving work to someone, I am relying on his intelligence and his skills. So, he has to use his skills. If he doesn't use it, if he acts negligently, if I suffer any losses, he will have to pay me those losses. It is his duty to make proper accounts. He has to communicate everything with me. He has to pay all the sums which he received from the third party. Then, bacha, he should not deal in his own account without disclosing it to me. So, there is again an exam question, but students get confused here. So, I am taking the 6th point. If an agent is acting in his own account without obtaining the consent of the principal and informing him, the principal may repudiate, that is, cancel the transaction. Example, Manasi again told Ajit that, Ajit, listen, I want to buy a house in this area. So Ajit found this house at a very good price, but Ajit is smart. Ajit bought this house in the name of his, let's say, brother Sujit. So Ajit is buying this house in the name of Sujit for 20 lakhs. Then he is showing that Sujit is selling it to him for 24 lakhs. And then Ajit is telling Manasi, Arey ma'am, you wanted to buy a house, now buy my house only. I bought it for 24, I'll sell it to you for 26. So in that case, bacha, if Manasi would have purchased the house in the first place, she could have got it for 20 lakhs. But because of this mischief of Ajit, she is buying it for 26 lakhs. So in that case, when Manasi comes to know, she can cancel the contract and she can claim 6 lakhs. That is your 6th point. Fine. And then what are his rights? Bacha, what are the rights of the agent? First, if I promise him commission and if I don't pay him commission, he can have right of lien. He can demand commission. Then whatever expenses he has incurred, advance he has paid, commission which he has, that he can retain out of the total amount. So if customer is giving him 5 lakhs and if his expenses are, let's say expenses, commission, everything is 50,000. So he is going to give 4,50,000 to his principal. He has a right to get protected for any expenses which he incurs in normal course or an emergency. Fine. So these were your duties and rights. Now, coming to a very crucial part, liability to third parties. Bacha, who is gonna be liable to third parties? Let me write here. Liability to third parties. A lot of questions they have asked from this. Chalo, tell me. Who is gonna be liable? Principal, right? So principal is liable in following cases. But you know, there are certain cases where agent is also liable. Agent is liable in following cases. First one, principal is liable when agent is acting within authority, then obviously principal is liable. Or agent is acting beyond authority and it is ratified by the principal, then principal is liable. Or where your agent is incompetent, if your agent is minor, then obviously principal is only going to be liable. Or where agent is doing some fraud, anything within authority. See, if it is within authority, still principal is liable. Or agent is acting in emergency and good faith, again principal is liable. Or it is estoppel or holding out. Now what is this estoppel or holding out? Actually he is not your agent, but because of your actions you are making people believe that he is your agent. Example, P, A, X sitting together, not knowing each other. P introduces A to X as his agent. So P tells X, this is A, my agent. A also keeps quiet and P is only introducing it. So think X will obviously think that A is P's agent. With that thinking, X sells goods. But who is liable for this transaction? Principal himself. So principal himself is gonna be liable for this transaction. Seventh one, principal is also liable for any notice sent to an agent. But you remember in partnership you have done one rule, notice to an active partner is equal to notice to the firm. If you give a notice to an active partner, the firm will be liable for that notice, right? Same point here. If a third party is giving a notice in agent's hands, that does not mean that notice is given to agent. It means the notice is given to the principal. So notice given to an agent, the principal is gonna be liable. And the eighth one which they have given you is unnamed principal. Now who on earth is unnamed principal? I will tell you once I finish my second part. Okay. Now you tell me when agent is liable. First one is the very simple. He acts beyond authority and it is not ratified. Then he himself is liable. Second one, when he himself agrees with the third party that I will be liable. Then okay. If you are only agreeing, then okay. Or third one, it is the custom. It is normal in your business where agent is going to be liable. So if you are working in an industry where agent is only responsible, then so be it. Agent is responsible because that's the custom of your business. Fourth one, when the agency is coupled with interest. Coupled with interest means he is acquiring personal interest. Means agent is getting something extra apart from commission. So I told my agent, you sell my goods for 10,000. He sold my goods for 15,000, but he told me only and only 10,000. 5,000 he is putting in his own pocket. That means he has acquired personal interest. So apart from commission, he is getting something extra. He is acquiring personal interest. So then so be it, you yourself will be liable. That's your fourth one. Fifth one, when is agent liable? When he is working for a foreign principal. So bacha, if your principal is a foreigner, third party is not going to sue the foreigner. Third party is going to sue the agent. Sixth one, yes, if agent accepts a negotiable instrument without disclosing that he is an agent. Suppose here A is signing or accepting a negotiable instrument, he has to mention that he is an agent. If he doesn't mention this, then he will be personally liable. Seventh one, after this they have given you when principal cannot be sued. Maybe because principal is a foreign ambassador, foreign diplomat. So bacha, if your principal is a foreign ambassador, foreign diplomat, third party cannot sue. Then third party will be suing the agent only. That's your seventh one. Eighth one. Eighth one is undisclosed principal. Now students mix up unnamed principal and undisclosed principal. So let me first talk about undisclosed principal. Now undisclosed principal, as the name suggests, you don't disclose the principal at all. That means agent enters into a contract with an outsider as if he himself is the principal. So third party doesn't even know that he is an agent, and obviously third party doesn't even know that there is some principal. So then so be it. Then you yourself will be liable, bacha. So undisclosed principal, the agent will be liable because he does not disclose the principal at all. He does not disclose the existence of the principal at all. But it's kind of fraud because you are hiding a very important fact from the X. So in that case, the contract will become voidable at the option of Mr. X. X can either rescind or affirm the contract, his choice. Now, unnamed principal. Unnamed principal, yes, what is this? Principal not having any name? No, it's a stupid joke there. But your unnamed principal means third party knows that A is an agent. Third party knows that there is some principal. But who is that principal? That is not known. See, undisclosed principal, existence of the principal is only not known. But in unnamed principal, existence of principal is known, identity is not known. So in this particular case, bacha, if this is the case, then principal himself is liable. See, he doesn't know the name of the principal, that is his problem. He will get to know this later. But at least X knows one thing, that A is not a principal, he is an agent. So X is gonna sue the principal. So unnamed principal, the principal himself is liable. Undisclosed principal, the agent is personally liable. So if you see this here, all these sections we did. Termination is fine, it's very, very simple. Undisclosed principal we saw, personally liable, agent is personally liable. And if third party comes to know, it is voidable at his option. Fine. Irrevocable is also fine. Coming to another crucial part. Sub-agent and substituted agent. Chalo, sub-agent, as the name suggests, agent's agent. So principal, agent, sub-agent. So P is the principal, A is the agent, and B is the sub-agent. Right. Please tell me, bacha, sub-agent is appointed by whom? Agent. Secondly, who is going to give him remuneration? Agent. He is going to report to whom? Agent. And bacha, who is going to be liable for his acts? Agent. So if you have understood this, bacha, I am making one statement. Just as there is a principal agency relationship here, there is a principal agency relationship here as well. So in this case, A is the principal of Mr. B. But you know, by default, appointing a sub-agent is not allowed because of a Latin term, delegatus non potest delegate. That is, a delegatee cannot further delegate. So, bacha, laws just tells you very simple thing. Principal trusted you, na, agent, with his work. Without asking principal, how can you give his work to someone else? It's not possible. So a delegatee cannot further delegate. So by default, appointing a sub-agent is not allowed. But however, there are exceptions. That means in these exceptions, sub-agent can be appointed. First one, very simple. Principal himself allows. Then so there is no problem if principal is only allowing. Or principal knows and he does not object. It is as good as allows only. Or you have appointed him for some purely ministerial work, means clerical work, very small work where more skills and brain is not required, cleaning work or something like that. So for ministerial work, yes, you can appoint him because the main work is actually still done by the agent. Or you appointed him in emergency when there was no choice, then it's okay. And lastly, Bacha, you are appointing him because it is very normal in your business. Now, in share industry or share market, you might have heard about broker and sub broker. So, appointing a sub broker is not a big thing, it's a small thing, it's a very normal thing. So, in that case, you can appoint. So, in these exceptional cases where sub agent can be appointed, but your principal is liable. But otherwise, agent will be liable for him. That is your sub agent. And like sub agent, you have substituted agent. As the name suggests, it's not agent's agent. It is principal's agent only. He's just replacing you for that work. For example, principal and agent, and principal told agent, listen agent, I want to sell my house on auction. So agent appointed a qualified auctioneer for the work. So whatever work was given to A, the whole work will be now done by the auctioneer. Agent's work is just to appoint a substituted agent. So substituted agent is also appointed by agent only. But the remuneration will be paid by whom? Principal, right? He is going to report to whom? Principal. Who is going to be liable for his acts? Yes, principal again. So, bacha, just as there is a principal agency relationship here, there is a principal agency relationship here as well. So, auctioneer has replaced A in this. A's work is just to appoint a good auctioneer. Once he appoints a good auctioneer, and if something happens, if this auctioneer does fraud and all, A is not responsible, it is the principal who is going to be responsible. But A's duty is to appoint a good substituted agent. So the difference between sub-agent and substituted agent. Bacha, one thing is same for both. Sub-agent is also appointed by agent and substituted agent is also appointed by agent. That's the similarity. But if I tell you distinction between sub-agent and substituted agent, bacha, sub-agent is going to do part of your work. Substituted agent has replaced you, he is going to do whole of your work. Another difference, remuneration given by agent, here Princey, reporting to agent, here Princey, then liable will be agent. Those 5 exceptional cases, principal will be liable. But substituted agent, always Princey only is going to be liable, right? Then I can say there is no privity of contract between P and B, there is no contract. But here there is a contract between P and auctioneer. Then sub-agent, in that sub-agency, agent will be liable till the end. Whereas in substituted agent, agent's work is just to name a good substituted agent. Once he does that, his work ends, he goes. Now it will be between P and the auctioneer. So that's the difference between sub-agent and substituted agent. I hope I am very clear. Yes? With this, we finish our chapter Indian Contract Act. Bye-bye.